Hi, Brian. How are you? Good. How are you? No, I have daily for people one. Nice little start to the day. I'm trying to think about. Yeah, I mean, that was really good. Where do you work again? A long time ago, once in Atlanta, but I don't think I would eat cake like, but I just really want to eat cake. Really? Okay. But we have a break from 12:05 to 1:45. It's a big break, girl. No, big deal. We can go both days. I want to take today, but I think tomorrow. That's great. I know. I need to read here. Well, you can't read that. I'm talking really trying to. I want her to go get it.
It's gonna be a pain in the ass.
Okay.
So.
No, I'm not gonna force you to go now. No, nobody like say no to us. To go. I don't want you to. I know. But what?
I think this is an insert.
No, definitely have not. I probably should. Because that might be that will something to say about it.
Good morning. Couple of administrative notes. Right, so as you can see, we have an attendance pin. I figured out how to fix D2L more accurately. I asked the right person how to fix D2L, and they told me. The other administrative thing that I wanted to flag for you is related to office hours. You may be used to a situation where when a professor is hosting office hours, their office door is open. That's fairly common. That's not how I operate. And the reason for that is I work with music because like ADHD brain. And so because I don't want to disturb all of my colleagues, my office door is always closed. But if I am at home to visitors, there will be a sign on the door that says, "Come on in," and just knock so that, you know, you don't sort of surprise me. Give me a second to put on pants. No, no, I don't do that. But just knock and then come on in if the sign is up. Okay. All right. So with that, let's begin. Ms. Silva, A sues B for violation of a federal statute in federal court. All right, so what is the source of jurisdiction for this claim? Right. Well, what kind of original jurisdiction?
Rising under.
Right, 1331. A decides to join a state law claim that A has against B for conversion because B stole A's bicycle. Now, assume that Rule 18 allowed the joinder of the conversion claim and the federal statutory claims. So we have met the joinder standard, whatever that is. Does it make any difference in terms of the federal court's ability to hear the conversion claims if they are derived from a common nucleus of operative fact or if they are unrelated?
Yes, if it's from the common nucleus, then it will give jurisdiction. Because Rule 18 has no relationship requirement, so it doesn't automatically satisfy.
Exactly right. Exactly right. Okay. Rule 18 does not require an inquiry into the relationship between the original jurisdiction claim and the joined claim. Which means if you are joining claims under Rule 18, which is the rule that allows a plaintiff to join every claim that they have against a particular defendant in a single case or controversy, then each claim has to have an independent source of jurisdiction. You can only join a Rule 18 claim if there is an independent source of jurisdiction, right? If there is a relationship between the two claims such that you could use supplemental jurisdiction, that's not a Rule 18 joinder, that's a Rule 20 joinder, or possibly a Rule 13 joinder if it's a counterclaim, right? So Ms. Silva's absolutely right. Rule 18 does not impose a relationship requirement, which means if you are joining claims under Rule 18, you must inquire into the court's source of jurisdiction. Okay? Questions? All right. So this concludes our sort of hypothetical discussion of joinder. Now we're going to get into talking about the problem presented in the Exxon case. Okay? So this one requires me to be a little closer. Hello. It was working before. All right. Well, that's why I bring mine. So, y'all, I'm going full dad. All right. It's working. This is not. All right, great. Good job. Good job, Tech. Okay. Okay. So, Mr. Massey, you are presented here with a couple of statements or functions that represent a pattern of claims. Which of them represents the pattern presented in Exxon? Okay, why?
Because only one of the plaintiffs had a claim that exceeded 75,000, and there's complete diversity.
Right. Okay, so that is correct. Okay, that the fact, and I mean, this is just a simple case of sort of like distilling the facts in the opinion down to their most simplest expression, right? That we have a set of plaintiffs who are all completely diverse to a defendant, but only one of the plaintiffs standing alone meets the amount in controversy requirement for 1332 jurisdiction. Okay, so Mr. Roberts, what is the question that the court is being asked to answer in this case?
Whether a federal court can exercise supplemental jurisdiction over additional plaintiffs' claims that the amount in controversy requirement, but one plaintiff does provide the court with original jurisdiction.
Okay, can you translate that into English? It's right, but let's simplify it a little bit.
If one plaintiff has original jurisdiction, but the others wouldn't necessarily actually get themselves in the court, and they actually combine the amounts of the controversy to make that requirement met.
Right. Okay. It's even possibly simpler than that, right? In that the question is, plaintiff A meets the standard for diversity jurisdiction. Can B, C, and D tag along? Okay. So Mr. Strawman, can you explain why it is that supplemental jurisdiction creates original jurisdiction that does not exist without it?
Yeah, so like,
Can you do it in terms that we'll understand? I don't say that to like pick on you.
actually, my understanding
Mhm.
of the last scenario that we just described,
Mhm.
we didn't have 1367A. We would have to create a way to get those parties to come in there, as opposed to like a class action, as opposed to creating a supplemental jurisdiction over each individual. Without the supplemental 1367, we'd have to get another way to get all the parties in there.
So if all we had was 1331 and 1332, do B, C, and D get to bring their claims? No. And so 1367 is creating jurisdiction over claims that otherwise would not exist. Okay? So exactly right and perfectly clear. Thank you. So, all right. Mr. Adams is not present. Mr. Knapp, what joinder rule is at work in 1 and 2 above, right, that we just talked about?
I said rule 20.
Okay, why?
Because I was looking, because you have to be, I think that's the one that has to be same nucleus, right? The same case or controversy on rule 20.
What's the standard in Rule 20, Ms. Henninger? Mr. Henninger, I'm sorry.
For rule 20A1A, it just has to arise out
Arise out of what?
the same transaction or series of transactions.
Right. So essentially, you've said it correctly. I just wanted to make sure that we got the language of the standard, right? That there is a relationship test in Rule 20. So if the plaintiffs are properly joined pursuant to Rule 20, as Mr. Knapp has said, what does this mean regarding the satisfaction of the relationship test under 1367A? Ms. Olive, can you help us with that?
Yes. It does satisfy it because if they join together. Can you give me one more?
Sure.
Thank you. Isn't it yes and satisfied?
Yeah,
Yeah.
why? See, that's the problem with yes, no questions. You got that 50-50 chance of guessing, but then I'm gonna ask you why.
Because they arise from the same transaction occurrence or series of transactions.
So, right? Let's break this down. What are the different types of joinder under the rules? Mr. Brown, what are the different types of joinder under the rules?
Well, I'm thinking of maybe infleating, I believe that's the term for it. Is that one of them where you would, a defendant can inflate another one and thus bring them into the claim?
What kind of joinder is that?
I don't know the proper legal term for it.
Okay. Ms. Feldkamp, can you give them some help?
I thought that was just, is that interpleader? Or is that wrong?
So interpleader is basically a game of let's you and him fight, right? So interpleader is where person A says B and C are both making a demand on me and I cannot satisfy them both. Court, figure it out. Okay. But what kind of joinder is interpleader? We talked about this on Thursday, guys. There are two kinds of joinder. The MEE asks a question that screws them up.
Or using please.
Joinder of parties and joinder of claims. Okay? So you can either be joining parties, right? So A and B have a dispute and they're bringing in C that is in some way involved, or you can have joinder of claims. A and B have a dispute and they also have another dispute that they're going to fight out in the same case and controversy, right? So which of these two types of joinders is at work in Exxon? Is it A versus B, we're dragging in C, or is it A versus B1, A versus B2, A versus B3? Ms. Morgan, which is it?
A versus B1, A versus B2.
Why?
There's a class permissive joinder, like they can join the class.
I'm a little confused. Permissive joinder of what?
Claim.
Okay. What are the claims in Exxon? Bear in mind, if it's joinder of claims, all of the claims are A versus B, A versus B, A versus B. Is that what's happening in this case?
No, I don't know.
Okay. Why don't you know? Never mind. That's not an appropriate question. That's not an appropriate question. So let's move on. Okay. So Ms. Velasquez, joinder of claims or joinder of parties? Why?
Because it's like A and E and C first.
Right. So we have in the Starkist case, right? Maybe it's a little clearer because the Exxon case is complicated, but the Starkist case maybe is a little clearer, right? We have a little girl who gets cut on a can of tuna, and she's suing Starkist over the harm that she suffered from the can of tuna. Her parents also suing for, claims related to the fact that they're upset over the harm that their child has suffered. Okay? Can the little girl bring a claim for the upset that her parents have suffered? Think back to your first year torts class. Can the little girl bring a claim for the emotional harm her parents have suffered? No, why not? Because that's not a harm that happened to her. The parents have to bring the claim, which means we do not have A versus B, right? We have A versus B, and we have C versus B. Sorry, it gets out of order. So this is a joinder of claims. Okay. So what is the rule that governs joinder of claims? Rules that govern joinder of claims. I'm sorry, I'm hearing like, so it's okay to volunteer, but be bold.
18 is joinder of claims, but I thought it was joinder of
Parties.
parties. So 20.
Right. Yes, thank you. I just pulled an MEE. So yes, joinder of parties, right? So rule 20. And if rule 20 joinder has been properly undertaken, how do we know that the relationship test has been met?
There isn't one. There, rule 22A says arising out of the same transaction occurrence or series of transaction occurrence.
Right. Our old friend, the Venn diagram. If we meet the rule 20 standard, we know we've met 1367A. Okay. Okay. So, excuse me. Sorry, I'm sitting here because I don't have the presenter view in front of me, so I'm going, what's the next slide about? I put these together yesterday and I've already forgotten what they have. Okay, so we come back to this and we're back to the question I posed to Mr. Knapp that he answered correctly and that Mr. Henninger helped us have the rule to answer. We've met our relationship test, and then does 1367B strip jurisdiction? Okay, Mr. Hoover, do you think that 1367B strips jurisdiction?
I'm not sure. I'm sorry. I lost my train of thought. Is this 23B?
No, this is still 22, as it says at the top. And we're still talking about the same two hypotheticals from DRQ 20.
And I apologize. I've lost my spot. I'm not sure.
Okay. So, Mr. Gonzalez, what do you think? Does 1367B strip jurisdiction in either of these cases?
Well, 1367B states that courts will not have supplemental jurisdiction over cases arising under subsection A if the plaintiff against the persons made parties under rule, including rule 20. So I would assume that yes, they would lose jurisdiction.
Okay, so you are correct that we have to ask about 1367B because we do have joinder under rule 20. However, does this claim meet that standard? Ms. Barral. Why not? Okay. Mr. Thompson, can you help her out?
I didn't hear what she said, but I think it does meet the standard in 1, but it does not in 2 because there's no diversity. There's diversity is destroyed in the second one.
Well, okay. So
Can I amend my answer?
sure.
I'll amend my answer because in 1367 it says claims by plaintiffs against people made parties under rule 20. And since these people aren't made as defendants 1367B does not strip jurisdiction.
Right. Okay, now, Mr. Thompson's raising an important issue, which is that in hypo 2, in hypo 2, there's this issue related to, do we have complete diversity? And yeah, we're gonna talk about that in a minute. So my last question on this DRQ is, let's flip the caption. Do we have supplemental jurisdiction over claims presented by E against B, C, and D? Mr. Gonzalez, I'm coming back to you.
I would say no, because then they're made parties under Rule 20 as the defendant, and that specifically goes against Rule 1367.
Exactly. It's not rules.
Code.
Yep. So, okay, 1367B, right, exactly right. Okay. So, questions about this? There's been a lot of this is a lot of moving parts. So if you're confused about anything, let's pause and make sure that we're all on the same page.
Could we go back one slide and could you repeat the answer for the last bullet? 1367B strict jurisdiction in this case. And so I don't know if Tom was right or if.
So Mr. Gonzalez was correct. Okay, because the question in 1367B, the first question is jurisdiction based on diversity? For both of these, right, the answer is allegedly yes. In 2, there's a complication that we're going to talk about later. But assuming that the answer is yes, then the question becomes, are the supplemental jurisdiction claims presented by parties joined under one of the rules listed in 1367B? Rule 20 is one of those rules, so we do have those claims present. However, where the statute fails to operate is it only operates against claims presented by plaintiffs against parties joined under one of the relevant rules, in this case, Rule 20. And that's why when you flip it, suddenly the supplemental jurisdiction gets stripped. Okay?
Thank you.
No problem. All right. Any other questions? All right. Ms. Caballero, once you have identified the relevant joinder rule from the previous question, right, Rule 20, consider whether the following is true. Okay? Is it true that in an action where subject matter jurisdiction is founded on arising under jurisdiction, there is supplemental jurisdiction over a party joined pursuant to Rule 20?
This is where I'm having a little trouble. I got through all of chapter 13 easy, but I'm just struggling with this matter. But I put yes because Rule 20A1A.
You're right, but it's actually even simpler than that. So, Ms. McHenry, can you help her?
I said true, that arises out of the same.
Ms. Brand, any more help?
I also just had true that diversity must always be.
Mr. Simmons?
They already said the same.
Yeah.
Mr. Gonzalez?
Because 1367B only applies to cases coming out of 1332.
Right. If your original jurisdiction comes from arising under, you can hang any related claim on the case. We do not inquire into 1367B, right? This is a little bit of a trick question, okay? Arising under jurisdiction ends the inquiry. You only have to ask about the relationship. You do not have to ask about the method of joinder. Okay? So, Mr. Van Diest. In an action where subject matter jurisdiction is founded on diversity jurisdiction, the relationship test of 1367A is satisfied for a party joined pursuant to Rule 20. But we need to check if 1367B strips the court of jurisdiction granted before we can conclude that supplemental jurisdiction exists. True, false?
It seems true to me, but I feel like I'm missing something.
Ms. Sadler.
I would say true because I think that's just the rule of B coming into play for Rule 20.
This is exactly what we've just been saying, right? So this question is tricky because it's so easy that you go, surely that can't be it. It absolutely can, and don't call me Shirley. So this, I'm gonna warn you guys, right? This is one of the things that the bar examiners love, is asking you a question that's so simple that you're like, this cannot be it. Sometimes it is. Sometimes it absolutely is. Okay? All right. Mr. Harrison, please identify the jurisdictional defect alleged in these two cases if subject matter jurisdiction is premised only on 1332.
And so if it's premised on 1332, diversity of citizenship, an example one,
why don't you just do example one and then we'll move on to example two. I just realized I sort of dropped a compound question in your lap.
okay.
So
Example one has defect of the failure to meet the non-controversy, not all of it.
right, okay. 1332 has two requirements: complete diversity and amount in controversy. The alleged jurisdictional defect in one, and this is the question that's presented in the Exxon case, is what do you do with claims that meet complete diversity but don't meet amount in controversy when there's another claim that does meet amount in controversy? Okay. Mr. Hoover, back to you. What's the jurisdictional defect in two?
So mountain controversy is met, but we don't have diversity, complete diversity, because two of them are from Alabama.
Exactly right, Ms. Gleason. This was the point you were making a minute ago. Okay.
Yeah.
These represent two different theories of how 1332 operates. And they impose different consequences on these two requirements. Okay, and the court in Exxon makes this point, I think, fairly clearly, right? And we'll talk about the court's language in a second. But these two theories are, for one, what the court refers to as indivisibility theory, which says that the district court has to have jurisdiction over every claim to be able to hear any claim. And the theory in two is what's called contamination theory, which says that a failure of original jurisdiction on any claim dooms all the claims, or deprives the court of jurisdiction on all the claims. Right? Doesn't doom it because dismissals on subject matter jurisdiction are without prejudice and you can refile in state court and blah, blah, blah. But these are the two theories. Indivisibility says everything or nothing. And contamination says screw up one, screw up all. Okay? So, questions about those two theories? Yes, Ms. Weston.
I'm not sure I understand the difference between them. It sounds like either one results in the associated claims being tossed out.
Excellent question. Let's move on and we'll answer it. So, Mr. Highstand, I'm going to refer you to question 25 in the case book because there's a long extract from the opinion attached to it. But in light of the extract of the opinion, please explain why indivisibility theory is inconsistent with the whole notion of supplemental jurisdiction.
Well, it leads to a more narrow construction of that statute. It prevents otherwise valid claims from being able to be brought forward.
I don't think that's wrong, but I would go even farther. All right, Ms. Stewart.
So the indivisibility theory is inconsistent because with supplemental jurisdiction, because supplemental jurisdiction allows courts to hear claims they otherwise wouldn't have original jurisdiction over. But under the indivisibility theory, that theory says if they didn't have jurisdiction over each claim, they couldn't hear it. So those two ideas just don't go to.
Exactly right. Indivisibility theory writes supplemental jurisdiction out of the code. Because if you have to have original jurisdiction over every claim to be able to hear any of them, well, then there's no longer any such thing as supplemental jurisdiction, right? Looking for the north-south nods or the east-west nods, right? Okay. So, supplemental jurisdiction only becomes relevant when there are claims in the case that do not have an independent jurisdictional basis. Okay. So, Mr. Heisen, you described it as narrowing the supplemental jurisdiction standard. I agree with that. The court points out that we are narrowing it into nothing. Okay. So, if every claim before the court had an independent jurisdictional basis, there would be no need for supplemental jurisdiction over any claim. Okay. Mr. Van Hee, you are going to close this chapter for us. So we're back to hypotheticals 1 and 2. Do you have an angle to see it? I know you're okay. We're back with hypotheticals 1 and 2. Okay. Why is it that supplemental jurisdiction can cure the defect in 1, but not in 2?
You can cure the defect in 1 because at least one of the plaintiffs meets both requirements of diversity, and the other claims of the other plaintiffs are so related that they form the same occurrence or transaction, so they can be joined. And since they're so related, the court may exercise supplemental jurisdiction, whereas they, in problem or example 2, since diversity is destroyed, they don't have 1332 anyway, so they can't exercise supplemental jurisdiction.
Right. Okay. So the court makes the point in Exxon that the amounting controversy requirement and the complete diversity requirements are different. Okay. The court accepts contamination theory for the diversity requirement, right? One non-diverse party deprives the court of jurisdiction over all claims. Okay. However, the court does not accept indivisibility theory for the amount in controversy. Because doing that eliminates supplemental jurisdiction altogether. So, Mr. Van Heet, why does the court differentiate between how it treats these two requirements?
For matters of efficiency, I would think that
What does the court say? Like you're getting ready to speculate, and I'm just going to stop you right there and say, the court tells us why it's doing this. So tell me what the court says.
the court says that it satisfies the rules, so they should be able to bring those claims.
Okay. Let's see. Ms. Duncan, what does the court say?
I was thinking the same thing as Nick, because they did allow it because the diversity of.
But the court explicitly talks about why one, which is the facts presented in the case, is fine, and two is not. Okay, Ms. Holman, can you help us? I'm sorry?
I said I'm not really sure.
Okay. Anybody?
So because of original jurisdiction, sorry,
You go ahead, Mr. Stronger.
the original jurisdiction isn't there for number two, therefore.
Ms. Morgan?
it's out.
So they say that the amount in controversy requirement does not affect claims the way that like allowing a case to stay in federal court when diversity jurisdiction is destroyed would, because the whole point of like having the federal court is to have an unbiased forum. So if you have a plaintiff and a defendant from the same state, I mean, it's just likely to be biased.
So I think that's a fair summary of what the court says. Here is what the court actually says. The contamination theory, as we have noted, can make some sense in the special context of the complete diversity requirement, because the presence of non-diverse parties on both sides of a lawsuit eliminates the justification for providing a federal forum. The theory, however, makes little sense with respect to the amount in controversy requirement, which is meant to ensure that a dispute is sufficiently important to warrant federal court attention. The presence of a single non-diverse party may eliminate the fear of bias with respect to all claims, which means that you don't have the reason for diversity jurisdiction ceases to exist. But the presence of a claim that falls short of the minimum amount in controversy does nothing to reduce the importance of the claims that do meet this requirement. Okay, so we've justified invoking the attention of the federal court because of A's claim, and B, C's, and D's get to tag along. It is fallacious to suppose, simply from the proposition that Section 1332 imposes both the diversity requirement and the amount in controversy requirement, that the contamination theory germane to the former is also relevant to the latter. There is no inherent logical connection between the amount in controversy requirement and Section 1332 diversity jurisdiction. After all, federal question jurisdiction once had an amount in controversy requirement as well. If such a requirement were revived under Section 1331, it is clear beyond peradventure, which is a court getting snooty about nobody can question this, that Section 1367A provides supplemental jurisdiction over federal question cases where some, but not all, of the federal law claims involve a sufficient amount in controversy. So let's translate this into normal person talk, right? How would you explain this to your grandmother? Simmons.
But I would just say Exxon, for the case, Exxon basically discriminates if one person meets the non-controversy. The case would be fine.
Well, specifically, how would you explain this extract to your grandmother? I don't think you're wrong, but I'm asking a different question. And it's cheating if any of your grandmothers are lawyers.
I would just say grandma from the same state, or if the person's from the same state, and that would not be under Exxon, it would be diversity matter.
Yeah, Mr. Shorn.
Going, same thing, grandma, sometimes when you have an issue of people from different states, you need to be in a federal court to make sure that it's a good forum, it's a good place, so you're not gonna get,
Good, right?
someone's gonna take it extra, it's better be heard in the federal court than it is in the state court. But if you're both from the same state, then you need to stay in that state.
I don't hate either of these explanations, but they feel incomplete. What might be missing here, Mr. Thompson?
If my grandma's a lawyer, can I read what I? May not be right, but it's.
Sure,
Okay.
sure.
If the defect is a mounting controversy, as is the case in number one, then this defect is cured if one of the claims is over 75,000, but the others aren't, because the case is still important enough to be heard by the district court. But if the jurisdictional defect is lack of diversity, as in.
Man, your grandma's snoring. Like, you're not wrong, but like, this is a really important exercise, because particularly if you're going out and you're going to be in a small firm in a rural community, you have to be able to translate the law into language that unsophisticated clients can understand. Okay. And look, I'm going to be straight with you. I first started asking this question, explain this to your grandma, at a place where students were used to the first words out of their mouth needing to be according to the case. And boy, every time a student said that, I just went, okay. So, Mr. Thompson, you are right. Everything you're saying is right, but it is not meeting the call of the question, which is how can we explain this to someone who doesn't understand the law? Mr. Gonzalez.
Would it just be, the way I would explain it, it all depends if there's home field advantage. If you got two teams playing on a third team's field, you're okay. If you've got if you got two different teams playing on one person's field, you're not okay. But if you got teams playing on a different field from the two teams, you're okay.
I get where you're going with this analogy. Here's why I don't like it. How do you explain staying in state court when you lack complete diversity? I think you can do it by extending your metaphor, but I want you to do it.
I was going to say, at that point, you'd say both teams are from the same school.
Right, it's a scrimmage, right? So I think that's, at that point, I kind of like it better, okay? But what's missing still? Who aren't we talking about at this point? Right. So how do they fit into this? And how do you explain how they fit into this to your grandma or your unsophisticated client?
Just bare bones. If it's good amount of controversy, they can join up. If not, it's a diversity issue, then they can't.
Yeah, I think that's more or less right. Okay. All right. Questions about supplemental jurisdiction before we move on? Yes, Mr. Christie.
1367B talks about claims, it excludes certain claims under like against plaintiffs joined by Rule 14 and 24.
That's not what it excludes.
Okay.
What does the rule say?
Says. Any civil action, yada, 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 district court shall not have supplemental jurisdiction over claims by plaintiffs against persons made parties under rule 14, 19, 20, or 24.
Right, so it's not claims against plaintiffs. It's claims by plaintiffs against parties joined.
And then something about claims by persons joined under rule 19.
Right.
Intervening under rule 24. Then it says when exercising supplemental jurisdiction is inconsistent. Does that, when exercising supplemental jurisdiction, apply to everything, or are the claims?
So this was the case that we talked about on Thursday, right? Remember, where some courts will allow plaintiffs to bring claims against joined parties as long as they didn't join the parties for the purpose of bringing the claim. Okay. So that's so when when Susan comes in and she's non-diverse, okay, but she's been brought in by the other defendant, then some courts will allow the plaintiff to say, or she's come in on her own, right? Some courts will allow the plaintiff to pursue claims against her. Not all, but some. Okay. Other questions? Yes.
For the tagging of to meet the amount of controversy, 75,000, do you need just A or just B or just C or just D to have 75,000 per the claim, or can A, B, C, and D each have 20,000 and still meet the 75,000 requirement?
Sorry, I've been puzzling over this one myself. Okay. Here is the rule. If you are dealing with joinder of claims, A versus B1, A versus B2, A versus B3, then you can add up the amount in controversy to reach the 75,000. If you are dealing with joinder of parties, A versus B, C versus B, D versus B, sorry, then somebody has to meet the amount in controversy. Okay? Because that's the ice cream cone that you put your sprinkles on. That's the Christmas tree that you hang your ornaments on. Okay? Does that answer your question? Great. What other questions are there?
What was the first example? You added it up.
Joinder of claims. Yep.
Is there a rule for the joinder of claims? I know where the parties rules for the amounts that can be added up to get to the 75,000.
To be perfectly honest, that is a case that you would have read in studying SMJ in Civ Pro 1. So that's a question that would have been discussed in discussing how do you meet the standards for diversity. And the answer is when you are dealing with joinder of, or it might have been in the joinder chapter, but when you are dealing with joinder of claims, like if a plaintiff is presenting several claims, they can add up, if they have a 20,000 claim and a 30,000 claim and a $25,000 claim, then that gets them to the amount in controversy. Because go back to 1332, okay? Does 1332 grant jurisdiction over claims or cases and controversies? Or maybe more helpful is, does Article 3 grant jurisdiction over claims or cases and controversies? Right. And so we are measuring jurisdiction in two ways, right? And when we are asking, can this plaintiff come in? We're going, okay, is there a way for us to open the courthouse doors? Now, what I will say, and I'm going to speculate a little bit, I would not be surprised if at some point in the next 5 to 10 years, the Supreme Court took a case that closed the courthouse doors in that way. And I say that because this Supreme Court has generally been in favor of closing federal courthouse doors to plaintiffs. And so I would not be surprised if at some point in the next decade, they took a case that presented the question of a joinder of claims where no one claim meets the amount in controversy, and they said, no, you can't add it up anymore. So right now, the rule is you can add it up if it's joinder of claims, but keep an eye out. I would not be surprised if that changed in the not too distant future. Okay. Other questions about supplemental jurisdiction? Yes.
Just to clarify, you can add it up so long as it's the joinder of claims?
Right.
Okay.
So same plaintiff presenting multiple claims, no one of them reaches the amount in controversy, but all of them together do. You can add that up to hit your 75,000.
But joinder of parties, that doesn't work out.
You got to have at least one of them that hits the 75,000.
Okay.
Now, if you have both, right? So if you have several parties and they're all presenting multiple claims, each party gets to add up the claims that they are bringing to try and meet the amount in controversy. So, you've got A versus E1, A versus E2, A versus E3, B versus E1, B versus E2, and so on and so on and so on, right? Each plaintiff is allowed to add up the claims to see if they can get to 75,000. Okay? All right. So since we have a minute left in class and we have reached the end of the chapter, this is a good time to wrap for the day. And we'll see you guys on Thursday when we will start with removal. So again, make sure you've prepped the first 10 questions of the chapter, and we'll see you then. All right, take care, guys.
Eric, you had mentioned that after the chapter on removal.
Skipping class action chapter.
Okay, skip, and that's 14.
Yep.
So continue with 15?
Yep.
Thank you.